Now, it's unfortunate that these rulings that are coming out of the court are so short. In the past, especially in 2013, we had detailed reasoned rulings on why applications were either granted or refused. That has not happened this time. Now, when you examine or when you listen to the ruling of the court, the only reason they give is that the rules do not allow for it. So if the rules do not allow for it, why has it been permitted in the past? And so we think that the petitioner is not being treated fairly in these circumstances. And it's unfortunate, but we have to say it as it is. The petitioner is not being treated fairly. Counsel for the petitioner made reference to a specific case, Elistamaklo, in which that related to an application for leave to file supplementary. Now that particular case, they were allowed to file a supplementary statement of case. The Supreme Court claims that it's distinguishable from this one. We disagree because we believe that the intent of filing these supplements is to aid the administration of justice. You all heard the very superior arguments of our counsel. He said there were fundamental errors with the decision. And so we disagreed with the court and thought that the petitioner has been denied a right to a fair hearing. And we referred to cases which said that if a petitioner on grounds of expedition is denied a right to serve interrogatories, that is a denial of a right to a fair hearing. And so we are saying that the refusal of applications are not fair to the petitioner in the light of the past and in the light of what is happening now.
The law is not about what you want, it is about what you will get. And this business of they're talking about fair hearing and all that, in one of the authorities that their lead counsel, Mr. Tajikaka, quoted, it was stated quite clearly there that speedy hearing is synonymous to fair hearing. When you come to court and your mind, with all due respect, is jaundiced, that you should expect a certain ruling from the court. That is what is occasioning you when the ruling goes against you. In the courtroom, I heard my sister Marietta also saying that their lead counsel preferred superior arguments. Really? Superior arguments. Indeed, if the arguments were superior, 9 justices will not find that argument not superior. So that position they are canvassing is neither here nor there. Since we are all contesting this election petition on CR 99, they should address their minds to the dictates of CR 99. And this business of His Excellency the President Nana Akufo-Addo being granted leave in the 2013 election petition to serve interrogatories on the EC. And this time round, the petitioner, John Dramani Mahama, is being refused. You see, we should not reduce the practice in our cause to ad hominem applications. That because something happened the last time, it should happen this time round. The court was precise that it had to do with relevance and matters in controversy between the parties. So if issues are joined and there is no matter in controversy, you don't come for interrogatories. The interrogatories you are seeking for can be gotten in cross-examination. Your case in court is not determined by the number of hours you stand on your feet talking. It's based on the content of your submissions.
You heard the lawyers of both sides addressing the press on what they make of the court hearings today. They've raised different matters. The NDC side say they believe that they've been treated unfairly, whilst the NPP side says that they are of the view that today's court hearing was full of fanfare and arguments by the lawyers of the petitioner was emotional. They have been joined by one of the spokespersons for the petitioner, Godwin Tamaklo. Mr. Tamaklo, you're welcome. You made strong statements accusing the judges of not being fair to you. Aren't these statements too strong?
To the extent that the application for interrogatories was refused, it amounted to not giving the petitioner the opportunity, as it were, fair hearing. Yes. And so I do not know how it can be suggested, even remotely, that such a comment is unfounded. That submission was actually made before the courts.
You cited the issue of the Nigerian case. When the Nigerian case was just a persuasive action to draw the judge's attention to something similar which had occurred, the judges were not obliged.
They came back and said in 2013, then candidate Akufo-Addo brought a similar application for interrogatories. It is not just Nigeria. Let's leave Nigeria. What about the 9-member panel in 2013? So it is within that context that Leonard Senior made the point.
But don't you, the judges can depart from their judgment and also remain with their judgment?
Is that what they have done? Is that what they said? That they are departing from their 2013 decision? I'm not sure about that.
Going forward, during the case in court or the argument in court, you heard one of the judges, Justice Electoral Mensa saying that some of these your interrogatories that you were talking about, the 12 questions you asked the EC, could be questions you could easily ask during cross-examination. You have an opportunity to ask them during cross-examination.
When you have declared in your ruling dated the 19th January that the questions are not relevant, how can those, quote, not relevant questions be now admitted under cross-examination? Under the Evidence Act, the only way that a question asked under cross-examination will not be permitted is that it is not relevant. So you have effectively armed the respondents, lawyers, to object when that question is now asked under cross-examination.
Tomorrow, it's likely that one of your witnesses will be put in the box for the case to go on and be cross-examined by the first and second respondents. First, who would your first witness be, and how ready are your witnesses for this particular cross-examination?
Honestly, we thought it was going to be today. We thought it was going to start today. So you saw General Mosquito was here ready. You saw him with the file. He was ready for the cross-examination. Yes.
So is he going to be your first witness?
I say he is ready. Our witnesses are ready. Even if the process is fast-track for us to continue today, he's ready.
Some of these principles are so rudimentary and basic. And so when you make them, and eventually all 9 judges, not one even dissented, then at the end of the day, it is just because either you knew of the rudimentary basic principles, or for convenience, or for some other act of inadvertence, you may have lost the import of the law. And that is exactly what happens. So I think in actual fact, we are very much aware of these rudiments. And that is what we push. And especially where you have incorporated everything in a statement of case, which the judges have already read. In my view, it's just a matter of spending a couple of minutes, drawing the court's attention to some basic key areas, and then let them rule on it. Because it doesn't matter how long your argument will go, if it basically defies the rudiments of the legal principles that we all know, the court will reject you.
Your colleagues on the other side during the argument made mention of a case in Nigeria where the Supreme Court of Nigeria, exactly, where the Supreme Court of Nigeria indicated or stated that, look, it was important to accept interrogatories. Don't you think that accepting this would have been good?
In the first place, it's also basic that
our jurisdiction is not bound by the decisions of courts of other countries, but there may be a persuasive effect. Yes, the court has said that even in the presidential election petition case in 2013, they accepted interrogatory, so there was no need, unless you just want to be verbose, to even go beyond Ghana. But the court have said specifically that times have changed, other things, intervening acts have come into play. But for me, I even take that aspect as orbiter. That's something that was said in passing. So two things, are they relevant? No. Interrogatories must assist the court to resolve issues. If they cannot assist the court to resolve issues, then it can only rather even delay the court, and at the end of the day, it will not have any positive impact on it. But the idea that once an application had been accepted previously, it must also be accepted now, then it takes away the same principle that these cases must be educated upon by the application of the discretion of the court. We are happy that the case itself is commencing tomorrow. Fortunately, everybody is watching. These rules have relaxed matters. Those who are unlettered can also understand. And the bottom line is justice will be served, whichever way. And then we move on as a nation.